Assalamualaikum warahmatullahi wabarakatuh. My name is Siti Fatima binti Usman. My metric number is 1251036. So our group 2, will be presenting about the challenges faced by Syarie lawyers in Malaysian legal system. So I begin our presentation with the objectives of our presentation. The first one is to understand what are the definitions of Syarie lawyers and how it developed in Malaysia. The second one is to identify what are among the challenges faced by Syarie lawyers in Malaysia. And the third one is to recommend solutions to overcome the challenges faced by the Syarie lawyer. Now we move to the definition of Syarie lawyer. Here, I provided two definitions. The first one is the general definition and the second one is definition provided under the Syarie Legal Profession Federal Territories Act 2019. So generally, a Syarie lawyer is a legal professional who specializes in Sharia law. So they often deals with matters pertaining to Muslim personal matter and Sharia criminal offences. Meanwhile, under Section 2 of Syarie Legal Profession Federal Territories Act 2019, Peguam Syari defined as a person who has been admitted as Peguam Syari at the Sharia High Court and who has been registered under this Act. We move to the development of Syari legal profession in Malaysia. So during the initial period of the advent of Islam in Malaya, specifically after the Malacca Sultanate era, Majalah Al-Ahkam Johor had enacted laws regarding to representation in court. So, according to this law, both defendant and claimant have right to be represented in court by anyone they had chosen. And this law also allows any person to become a representative as long as he able to carry out these duties properly. So during this time, no specific requirements were needed. And then, before the independence, the administration of the religion of Islam enactments of each state allow a person to appear before the court as a Sharia lawyer. However, this representation only limited in mal procedure. For example, Section 51 of Selangor Administration of Muslim Law Enactment 1952 allows party to appear before the court with representative only in one procedure. Meanwhile, in criminal procedure, the parties need to attend the court session alone. Now, after the independence, the administration of Syarie lawyers have been improved. Why? Because Syarie lawyers had been recognized as an official profession in Malaysia. So, Syarie lawyers in Malaysia are administered under Syarie legal practitioner rules of each state. For example, here I provided among the rules of the state. So basically, all these rules contain provision in regard to the admission, registration, requirement, and the professional practice of Syarie lawyer in Malaysia.
Assalamualaikum. Hi, my name is Amra Balkis binti Muhammad Amin Nazli, metric number 1253487. For my part of presentations today, I will be discussing regarding the challenge faced by the Syarie lawyer in Malaysia, which is jurisdictions limitations. To begin with, Syarie lawyer in Malaysia are only authorized in the Sharia court. Unlike the civil lawyer, their scope of practice does not extend to the civil court for the Sharia lawyer. These limitations exist because the jurisdictions of the Sharia court itself is constitutionally and statutorily restricted. To be specific, the Sharia court only have jurisdictions over a persons that profess the religions of Islam or we call as a Muslim. Their jurisdictions further limited to matters involving Muslim personal law, inheritance, custody, marriage, divorce, and also minor offense of Islam. So as a result, Sharia lawyer can only handle matters that specifically fall within this type of area, which means that any matter that beyond this limit fall outside the Sharia court jurisdictions, which means that the Sharia lawyer cannot handle that type of cases. So this shows that jurisdiction's limitations is one of the challenge faced by the Sharia lawyer in Malaysia. The problem become more significant when there is overlap or conflict between the Sharia court and also the civil court. Malaysia operates under the dual legal system where both court coexist and practice different jurisdictions. Article 1211A of the Federal Constitution provides that civil court cannot interfere with any matters that fall within the jurisdictions of the Sharia court. However, this provisions does not entirely remove the power of the civil court. So we can see that one important power that remain exclusively is the judicial review. Judicial review is a fundamental part of a constitutional governance. It allows civil court to review decisions made by public authorities to ensure that the decision comply with the law and also the constitution. Therefore, when a dispute involves questions of jurisdictions, constitutional interpretations, or administrative actions by Islamic dispute, it gives the civil court power to hear and determine that cases. This has direct impact on the Sharia lawyer since judicial review fall within the jurisdictions of the civil court. Sharia lawyer was not permitted to represent their clients in the proceeding. Even if originally the cases was started in the Sharia court, but since it's fall now within the civil court for the judicial review, the power of the Sharia lawyer was automatically banished from that case. Further, these jurisdictional limitations can be clearly seen in the case of Indira Gandhi anak perempuan Muatho and Pengarah Jabatan Agama Islam Perak. In this case, Indira Gandhi, a Hindu woman, was married under Law Reform Marriage and Divorce Act 1976. During the marriage, the couple had 3 children. In 2009, the husband converted into Islam and unilaterally converted all the 2 children without the wife's consent. He later obtained a custody from the Sharia court. When the wife found out, she applied for the judicial review in the civil court, arguing for the validity of the conversions and also the custody. The federal court held that Article 1211A of the Federal Constitution does not exclude the jurisdictions of civil court to exercise the judicial review. The court further explains that the Sharia court cannot expand its jurisdiction beyond the constitutional limit, and thus the non-Muslim wife had no locus standi to appear before the Sharia court. From a legal analysis perspective, this case demonstrates the practical impact of the jurisdictional limitations on the Sharia lawyer. When jurisdictional conflict arise, the dispute will be decided by the civil court, and the Sharia lawyer will have no power to represent their clients in the proceeding. This significantly restricts their professional role even in the case that involve Islamic law and also Sharia court decision. Thus, we can see that jurisdictional limitations remain as the major challenge faced by the Sharia lawyer in Malaysia, mainly in case involving overlapping jurisdictions between the Sharia court and also the civil court. Next, I will pass to the next presenter.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Khalisatul Husna, metric number 1250818. So today I'll be continuing the discussion about challenges that were faced by Sharia lawyers. So another significant challenge faced by Sharia lawyers is the increasing need to engage in constitutional litigation. Although the Sharia courts enjoy autonomy over matters falling within the jurisdiction, such autonomy is not absolute and operates within the framework of the Federal Constitution. In practice, the civil courts, particularly the federal court, retain the final authority in determining jurisdictional boundaries and the constitutionality of Sharia laws. As a result, Syarie lawyers are increasingly required to argue cases within a constitutional framework, even where the core issues arise from the Islamic law. This development necessitates a broader legal skill set, including a sound understanding of constitutional principles and civil court procedures, which extends beyond traditional Sharia advocacy. These jurisdictional overlaps have significant implications for the predictability and consistency of Sharia legal practice. Legal uncertainty may arise. Legal uncertainty may arise when litigants pursue parallel proceedings in different courts, leading to jurisdictional deadlock, delays in the administration of justice, and confusion regarding the appropriate forum. The case of Subhashini Rajasingham versus Saravanantara Tungge 2007 illustrates this problem, where disputes emerge after one party commenced proceedings in the Sharia court while the other sought relief in the civil court. Such situations place Syarie lawyers in a difficult position, as they must carefully navigate overlapping legal frameworks while simultaneously safeguarding their clients' legal and constitutional rights. This challenge is further compounded by the institutional limitations of the Sharia courts. Unlike the civil courts, Sharia courts do not possess jurisdiction to interpret the federal constitution or to exercise judicial review over the validity of state legislation. Consequently, when conflicts arise between Sharia law and constitutional rights, such as issues relating to equality, personal liberty, and freedom of religion, Syarie lawyers have no choice but to bring these matters before the civil courts. This reality reinforces the need for Syarie lawyers to be proficient in constitutional law and civil litigation, despite such areas traditionally falling outside the core of Sharia legal training. In contrast, constitutional issues form an integral part of civil legal practice and legal education. Civil lawyers regularly engage with constitutional interpretation, judicial review, and questions concerning the validity of legislation. Furthermore, the civil courts possess original jurisdiction to adjudicate constitutional matters, allowing civil lawyers to initiate proceedings directly in the High Court or Federal Court without facing the same forum constraint encountered by Syarie lawyers. As a result, civil lawyers benefit from greater procedural certainty and clearer litigation strategies, highlighting the structural and practical challenges faced by Syarie lawyers when dealing with constitutional issues. That's all from me. Thank you.
To conclude, Syarie lawyers play a significant role in the Malaysian legal system, particularly in the administration of Islamic law. They are responsible for representing parties in Sharia court and ensuring that justice is delivered in accordance with Islamic principles. However, Syarie lawyers face several challenges. These include limited jurisdiction, constitutional issues, and conflicts between Sharia law and civil law. In addition, public misunderstanding about the role of Syarie lawyers has negatively affected the image of the profession. Many people are still unclear about their functions and authority. Furthermore, regulatory issues and lack of uniform professional standards have made career development more challenging for Sharia. Therefore, improvements and reforms are necessary to strengthen the Sharia legal system and ensure it is effective, respected, and relevant in modern society. Therefore, we need to have continuous training for Sharia lawyers. Sharia lawyers should be encouraged to attend ongoing legal training, and professional development programs. For example, annual workshops on jurisdictional conflicts between the Sharia court and the civil court. This will enhance their legal expertise and reduce errors when handling complex cases involving constitutional and Sharia law. The second one is increasing public awareness. Educational programs should be conducted to help the public better understand the role of Sharia lawyers. For instance, awareness campaigns through social media and community programs can be introduced. This will reduce public misconceptions and improve the image of the Sharia legal profession. Third, harmonization between Sharia law and civil law. There should be greater cooperation between Sharia and civil legal institutions. For example, joint dialogues and forums involving Sharia judge and civil court judge can be held. This can help prevent conflicting court decisions, create a more consistent legal system. Fourth, uniform professional standards. There should be standardized regulation, ethics, and qualification for Sharia lawyers throughout Malaysia. For example, the establishment of national regulatory body to oversee the profession. This will ensure consistent quality of legal service and strengthen the professional standing of Sharia lawyers. In conclusion, this recommendation aim to improve the effectiveness, credibility and professionalism of Sharia lawyer in Malaysia. Thank you for your attention.